Please tell me your name.
Lena Hartman.
21MM7943. Ma'am, you're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. All right, ma'am, your bond is $500 with special conditions.
Your Honor, I'm so sorry. It looks like she has a victim coming in.
Oh, I didn't see anybody. Thank you. Good morning. Would you like to testify this morning?
Well, I came over here because I'm not here to press charges.
Sir, if you want to speak, you have to be sworn in. Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Freddy Figueroa?
All right, I'm going to let the prosecutor ask you some questions.
Mm-hmm.
Good morning, Mr. Figueroa. Can you please state your relationship to Ms. Hartman?
My girlfriend.
Are you afraid of her?
No,
Has anything like this ever happened before?
never.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yeah, if it happened, yes.
Okay. Do you believe drugs or alcohol were involved in this incident?
No, ma'am.
And do you want to have contact with Ms. Hartman while this case is pending?
Oh, yeah.
All right, thank you.
Well,
Does the defense have any questions?
No questions, Your Honor.
All right, sir, is there anything else that you wanted to tell me this morning?
not really. Just that I don't want to press, charges. Just
So that's a discussion you're going to have with the state. Right now, she's being prosecuted by the state of Florida, not by you. So it's not really up to you whether the state files the charges or not. But for purposes of today, it does matter if you want to have contact with her. And I just want to clarify, you said you do want contact with her?
yeah.
All right. Ma'am, your bond is $500. You can have only peaceful contact with the victim. Do you understand what peaceful contact means? No hostile contact. Don't even raise your voice. You can't possess a weapon, firearm, or ammunition. Are there any other conditions the state would request?
No, Judge.
All right. Good luck, ma'am. Thank you, sir. Good luck.
Thank you.
Please tell me your name. All right, sir. You're here in 21MM7919. This case was reset from yesterday. Mr. Brantz, do you know why?
It was a mental health reset, Your Honor.
There was an offer, if I can have a moment. I didn't speak to him before court.
Go ahead.
Thank you.
Thank you.
Thank you, Your Honor. We did review the plea form and the offers, I believe, adjudication of guilt and credit time served. Spoke about the citizenship and probationary issues of entering a plea, and I believe Mr. Brodus wishes to enter a plea today.
Sir, please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yeah.
Thank you.
All right, Mr. Brodus, you can put your hand down. You had the opportunity to speak with your attorney today about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yeah.
Did you have a chance to review that form in front of you? It further explains those rights to you. All
Yeah.
right, do you have any questions for me about the rights you're giving up if you enter a plea of guilty or no contest? What questions do you have?
No, I have a question.
All right, so you understand you're giving up your right to a jury trial when one is required, your right to remain silent, your right to testify on your own behalf. We're not going to have a trial here today. You understand that?
Yeah.
All right, sir. You understand if you're on probation anywhere, this plea could violate it.
Yeah.
If you're not a U.S. citizen, you can be deported. Do you understand?
Yeah.
All right, sir. At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the
3 days.
3 days you've been in custody. Sir, I have to order that you pay court costs. I'll give you a year to pay those. And you're not allowed to return to the Links Central Bus Station. Do you understand? All right, good luck, sir. You have 30 days to appeal in writing.
Were we appointed in that case, Your Honor?
You were, yes.
Thank you.
Good luck, sir. You were yesterday.
Understood. Thank you. May I approach?
Yes, please. Thank you. Thank you. Please tell me your name.
Good morning, Your Honor. My name is Martin Alexander Yamas Koda.
Sir, you're here in 21 CF 11967. A capias was issued for your arrest and an information was filed charging you with battery with one prior offense. Your bond is $5,000 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, Your Honor.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings if that is needed. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir.
Your Honor,
Your
I
Honor,
sir.
there's an additional case.
may I speak, please?
Hold on a second. What'd you say, Ms. May?
There's another case as well, Your Honor. 21 CF 14023.
No, I have that he's not here on that case.
Delete the do not return.
Mm. Oh,
Actually, he is here on both cases.
he is. Okay, hold on one second. Actually, I need to change that order, Mr. Brantz. The condition instead of, no, that's a different case. But I do need this one as well. Okay. But can I see the other one? Hold on one second. So I don't know why mine says he's not here on both. All right, so in this case, instead of maintain separate and one-time return, it is just simply no return to the scene, and you can't be within 1,000 feet of the victim's residence or place of employment. And then it looks like you are here in another case. I'm sorry, it said you weren't. This case is 21 CF 14023. A warrant was issued for your arrest, charging you with aggravated stalking after injunction and violation of a domestic violence injunction. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Give
Your
me
Honor,
one
when
moment.
Setting bonds, it would have you take into account that it is the same victim as in the battery one prior DV. Also, he has had a prior VOP showing an inability to comply with court orders. So it would just have you take that into account when setting bond on those two charges.
All right, hold on. I don't have him. I don't have him in the clerk system either, so I don't have this. I need the affidavit for this warrant. Does anybody have it?
One second, Your Honor.
All right, it's not in the clerk system. We may have to bring him back because I can't address bond until I review that.
I have the warrant, Your Honor.
No, I need the affidavit.
Oh, that's the affidavit for the arrest.
You have the affidavit? Ooh, if you could print that.
One second.
Sorry for the confusion. My paperwork says he's not here on this, and it's not in the clerk system. Thank you. Ms. May, are you able to print it or do you want me to ask the clerk?
I was able to print page 1. Our printer is being incredibly, I think it's coming.
All right, let me ask the clerk if she can print it for us.
Your Honor, I have it.
Okay. All right. Thank you, ma'am. All right, so I've been able to now review this affidavit. Is there anything else from the state on this? You said it's the same victim in both cases.
It is, Your Honor. And given the allegations in the ag stalking after injunction and violation of domestic injunction case, in conjunction with him being arrested for the BAT 1 prior DV, state would just have you take into account all the prior arguments already made.
All right, anything from the defense, Mr. Brands?
Your Honor, Mr. Cota is entitled to bond on these charges unless a pretrial detention motion has been filed. I know we've had this discussion many times on these types of cases, and there are other orders you can include that aren't included in a general injunction, curfew, checking in with pretrial supervisor, relinquishing any and all weapons. I would just have you consider that in your determination.
All right, sir, on the aggravated stalking after injunction, your bond is $25,000. The violation of domestic violence injunction, your bond is also $25,000. You've already been ordered by at least one judge, possibly two, not to have any contact with the victim. These charges indicate to this court that you're having trouble understanding what that means. I'm going to explain it to you, and I want to make sure that you understand it. You cannot speak to the victim. You cannot call the victim on the phone. You cannot leave a phone message. You cannot text the victim. You cannot contact her through friends or family, and you cannot contact her on social media. Is that clear?
Yes, Your Honor.
You can't possess a weapon, firearm, or ammunition. You can't return to the victim's residence for any reason or be within 1,000 feet of the victim's residence or place of employment. Do you understand that?
Yes, Your Honor.
Any other conditions the state would request?
Your Honor, the state would only request that he comply with the injunction in 21 DR 8404.
You have to comply with all of the conditions in that injunction. Good luck, sir.
Thank you, Your Honor.
Please tell me your name.
Nelson Alexander.
Oh,
Hopper.
not you, sir. I'm starting with her. One more time.
Alicia Hopper.
All right, ma'am, you're here in 21 CF 14373 because a warrant was issued for your arrest, charging you with aggravated battery with a deadly weapon. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Good morning, sir. Did you wish to testify today?
No, ma'am.
Did you say no?
No.
Okay, thank you. Sorry, sometimes with the masks, it's hard to understand. I just want to make sure I heard you.
All right.
All right. Does the state wish to be heard on bond here?
Your Honor, state would just ask for a reasonable bond as Ms. Hopper is otherwise entitled to it. I do believe the injuries sustained by the victim were pretty significant, including a gaping laceration in which had to be transported to ORMC to be seen for. So state would just ask for a reasonable bond in conjunction with no contact at this time.
Anything from the defense, Mr. Brands?
I concur. We would just request a straight, reasonable bond, Your Honor.
All right, ma'am, your bond is $15,000. You can have no contact with the victim. Do you understand what no contact means?
Yes, Your Honor.
You can't possess a weapon of any kind, firearm or ammunition. You may not return to the victim's residence or be within 1,000 feet of his residence or place of employment. Good luck. Thank you, sir. Good luck. Please tell me your name.
Irina Jones, IRENA JONES.
Thank you. You're here in 21 CF 13432 because a capias was issued for your arrest and subsequently an information was filed charging you with tampering with a witness to hinder communication to law enforcement and battery, domestic violence. There, of course, is probable cause, and the state has already filed a charging document. Your bond is $1,500 on count 1, $500 on count 2. You can have no contact with a victim or any witness in this case. You must maintain a separate residence. You may not return to the scene of the crime, and you may not possess a weapon of any kind, firearm or ammunition. Do you understand?
I'm sorry, I cannot go home.
I'm sorry?
That means I cannot return to home.
If that's where this occurred, you cannot.
My husband left in July, and
So I don't have jurisdiction over your husband. I only have jurisdiction over you. What I can do is I can order that you maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim and you can't live with the victim. So if he's not there, you can live there. But if he is there, you cannot live there. Do you understand? All right, good luck.
Delete the do not return.
Yes. Please tell me your name.
Name Miles.
All right, sir, you're here in several cases. In 21 CF 14519, you're charged with burglary to an unoccupied structure, resisting an officer without violence, and grand theft. There is probable cause, and I'll appoint an attorney to represent you in that case. Your bond is $3,500 on count 1, $500 on count 2, $500 on count 3. You can't return to this scene for any reason. You can't have contact with any victim or witness in this case. You can't possess a weapon of any kind, firearm, or ammunition. In 21 CF 14520, you're here charged with a burglary of an unoccupied structure or conveyance. The bond in that case is also $3,500 with all of the same conditions. So you can't possess a weapon, firearm, or ammunition. You can't return to the scene for any reason. You can't have contact with any victim or witness. In 21 MM 7928, you're here charged with battery, domestic violence. There's also probable cause for that charge. Your bond on that is $500. You can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You can't return to the scene for any reason. You can't be within 500 feet of the victim's residence or place of employment. Do you understand? Hold on, sir. You can ask me anything you want, but I want to make sure you understand everything you say is being recorded and can be used against you later. You understand that? I'm going to give you a moment to talk to your attorney.
That was 500 feet.
Is there a named victim in the domestic violence case, Your Honor?
Is there what?
A named victim?
There is Kizzy Ward.
All right. All right, and then in 2016 CF 292, 2016 CF 1360, and 2016 CF 519. Warrants were issued for your arrest for violating your probation in each of those cases. I'll appoint an attorney to represent you. You have no bond authorized in those cases, and the affidavit alleges that you violated by changing your residence, by failing to report as directed, by, oh, it looks like those are the allegations. And that you were not compliant. All right, sir. Stay in touch with your attorney, okay? Good luck. Please tell me your name.
Aisha Olivari.
21 CF 14537. You're here charged with aggravated battery with a deadly weapon, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Good morning. Did you wish to testify?
Yeah.
Please raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Please state your name for the record.
Francesca Gonzalez.
Wait. I couldn't hear you. One more time.
Francesca Gonzalez.
Thank you so much. Go ahead, Miss May.
Good morning, Ms. Gonzalez. Can you please state your relationship to the defendant?
My girlfriend?
Are you afraid of her?
No.
Has anything like this ever happened before?
No.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yes.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with her while this case is pending?
I do.
I couldn't hear that.
I said I do.
You do. Okay, thank you.
Is there anything else you'd like to tell the court?
No, that's it.
All right, thank you.
Anything from the defense?
No questions, Your Honor.
You can
All right,
stay
thank
there
you.
so can listen.
Thank you.
You can stay there so you can hear.
Yeah, you can stay right there while I'm addressing her case. What says the state as to contact?
Your Honor, given that allegedly in the affidavit there was a bat as well as a metal pole used, state would ask for no contact at this time. Understanding that the victim does want contact, however, state believes a cooling off period may be the best, given that there were 2 individual weapons used.
Mr. Brandt, did you wish to be heard about that?
The victim did testify to wanting contact. I would just have you order no hostile contact, Your Honor.
All right. Thank you both. Ma'am, your bond is $5,000. At this time, I am going to order no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You understand?
Yes, ma'am.
All right. Good luck, ma'am. Good luck, ma'am. Thank you.
I have a
Yes.
question.
I'm sorry.
I have a question.
Yes, ma'am.
Being that I already moved out, is she able to still go back to her apartment now that I officially left?
She is. So I'm ordering her to maintain a separate residence from you, but if you're not living there, she can go back there.
All right.
She just can't live there if you're living there.
Okay.
So, yes, thank
All
you.
right, thank you.
Good luck.
Jennifer O'Neill Torres is in the hospital.
21 CF 14543.
I believe we have a victim, Your Honor.
I'm sorry, what?
I believe we have a victim approaching.
All right.
Maybe we waive
I'm
the,
appointing your office, Mr. Brandt.
we'll waive the appearance, Your Honor.
All right. There is probable cause. Sir, did you wish to testify?
Yes, ma'am.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Joshua Vasquez.
Go ahead, Ms. May.
Good morning, Mr. Vasquez. Can you please state your relationship to Miss O'Neill Torres?
Boyfriend.
Are you afraid of her?
No.
Has anything like this ever happened before? Can you answer out loud, please?
No. She.
I can't hear you, sir.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yes.
Do you believe drugs or alcohol were involved in this incident?
No. I'm sorry, what was that?
Do you believe drugs or alcohol were
No.
involved?
No.
No? And do you want to have contact with her while this case is pending?
Yes.
Is there anything else you'd like to tell the court?
Just to take into consideration that she has health issues at this moment.
Sir, I can't really understand you. Can you just get closer to the microphone, please?
Yes, that please take into consideration that her health has gotten way worse in the past couple of months due to COVID, and she's even waiting to get a pacemaker because of her heart issues after COVID. So she has a lot of her plate at this moment.
All right, thank you. At this time, her bond is $5,000 on count 1, $5,000 on count 2, and $100 on count 3. She can have no contact with the victim or any witness. She can't possess a weapon of any kind, firearm, or ammunition. She must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather her belongings. Thank you, sir. Good luck.
Your Honor, can we bypass Mr. Robinson?
Yes. Please tell me your name.
Gail Gillette.
21 MM7941. You're here charged with battery, dating violence. There is probable cause. I'll appoint an attorney to represent you. Hold on one moment. Your bond is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
I couldn't hear you.
Yes, ma'am.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, ma'am.
All right, good luck. Please tell me your name.
Antonio House.
21 MM7950. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Sir, you're also here for a violation of probation out of Hillsborough County in 19-17672. At this time, there's no bond on that, and I'll appoint an attorney to represent you. We'll notify them that you're here so they can transport you.
Well, thank you.
Good luck. Please tell me your name.
Stephanie Jones.
21 MM7948. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you in this case. Your bond is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition.
Okay.
You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Good luck, ma'am.
Your Honor, there was alcohol alleged within the affidavit.
Ma'am, I'm also going to order that you can't possess or consume alcoholic beverages.
Yes, ma'am.
Thank you, Ms. May. Please tell me your name.
Gabriella Martin.
You're here in 21 MM7947, charged with battery, dating violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes, ma'am.
All right, good luck, ma'am. Please tell me your name. Ma'am, I need you to look at me during the proceedings. Don't look at the witness, okay? You're here in 21 MM 7952, charged with battery, dating, violence. There is probable cause. I'll appoint an attorney to represent you. Good morning. Did you wish to testify?
No.
All right, thank you. Ma'am, your bond in this case is $500. With special conditions, you can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. You also cannot possess or consume any alcoholic beverages. Do you understand? All right, good luck, ma'am. Yes.
She's not from here. She's from New Jersey. She doesn't have nowhere to stay.
That's not something the court can help her with. She's gonna have to figure that out. She can talk to her attorney about it.
All right.
Good luck. Please tell me your name.
Cristiano Ortiz.
21 MM 7951. You're here charged with battery, dating, violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck, sir.
Your Honor, state would also ask for no contact with the witnesses.
I will also order that you can have no contact with any witness in this case.
Yes, ma'am. What else was that before that?
I'm sorry?
What did you say before that? I'm sorry. I was signing.
No contact with the victim, no contact with any witness. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow you to go back one time with law enforcement to gather belongings, but you can't coordinate that with the victim or any witness.
Okay.
Good luck. Please tell me your name.
Waldo Patino.
21 MM 543. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you. Good morning. Did you wish to testify?
Yes.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes.
Please state your name for the record.
Esmeralda Labarico.
I'm going to ask the prosecutor if she has some questions for you.
Good morning, ma'am. Can you please state your relationship to Mr. Patino Vasquez?
He was my partner.
Okay. Are you afraid of him?
Yes.
Has anything like this ever happened before?
Yes.
Approximately how long ago would you say the last time was?
It was April.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yes.
Do you believe drugs or alcohol were involved in this incident?
No.
And do you want to have contact with him while this case is pending?
No.
Thank you, ma'am. Is there anything else you'd like to tell the court?
We have kids together. So what would happen?
I'm sorry?
We have kids together. So if I don't want contact with him, then is he gonna be able to see the kids?
Possibly not at this time. Were any of the children present for this incident?
Both of them were.
No. He can't have any contact with the children at this time. So his attorney's gonna have to file a motion in front of the trial judge to get that order changed. And then if you have a family law case going on, that'll be separate. This won't affect that. But at this time, he's not going to have any contact with you or the children.
Okay, and I also have another question.
Yes.
We live together, but I don't want to stay in the house. I just asking for him to give me a week to get my stuff out, and he can get the house. I don't want it.
So I'm going to order that he must maintain a separate residence from you and allow him to return one time with law enforcement to gather his belongings. So he can do that, and then if you do move out of the house, he can return to the house, but he can't be there when you're there.
Yes.
So he's gonna have to talk to his attorney to figure that out because he can't contact you at all.
Mhm.
That's my order.
Okay.
All right, sir, did you hear that?
Yes, ma'am.
You can have no contact, your bond is $1,000. You can have no contact with the victim or the witnesses, which are your 2 children at this time. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. Mr. Brantz, can you make a note in your file for your colleagues? Because she just said in court that she's going to move out soon, but there's no way for the court to, I can't give him 7 days and then he can return. So he's gonna have to file a motion in front of the trial judge. But if you can make a note of that, so your colleague knows. All right. Mr. Patino Vasquez, you can also not possess any weapon of any kind, firearm or ammunition. Do you understand?
Yes, ma'am.
And you understand what no contact means?
Yes, ma'am.
All right. Good luck, sir. Thank you, ma'am. Good luck.
Thank you.
Please tell me your name. You're here in 21 MM 7929, charged with battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Good morning. Did you wish to testify?
Yes.
Please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, to help you God?
Yes.
Please state your name for the record.
Marilyn Jimenez.
Go ahead, Ms. May.
Good morning, ma'am. Can you please state your relationship to Mr. Santiago?
He is my boyfriend.
Are you afraid of him?
No.
Has anything like this ever happened before?
No.
If anything like this ever occurred in the future, would you feel comfortable calling 911?
Yes, ma'am.
Do you believe drugs or alcohol were involved in this incident?
Alcohol.
And do you want to have contact with him while this case is pending?
Yes.
And is there anything else you'd like to tell the court?
Yes. We just recently moved into an apartment on October 13th. So it hasn't even been a month yet. We're both on the lease due to what has happened. If he's not able to live there, I will try to go back to New York with my mom and transfer back to New York because I'm originally from New York. But we're both on the lease.
All right, so at this time, I'm going to order him to maintain a separate residence from you and allow a one-time return with law enforcement. So he is not going to be able to live there as long as you're there, but I'm not ordering you to leave. The court does not have jurisdiction over you. I only have it over him.
Okay.
So, did you hear what I said, sir?
Because he doesn't have a place to live.
He can find a place. Right now, he cannot return to that residence. Do you understand? You have to answer out loud.
Yes, ma'am.
All right. Your bond in this case is $1,000. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon of any kind, firearm or ammunition. Maintain separate, one-time return. You can't possess or consume alcoholic beverages. You'll be subject to random alcohol screens while you're out on bond. Any other conditions the state would request?
No, Your Honor.
All right, good luck. Thank you, ma'am. Good luck.
Your Honor, Mr. Robinson, he's gonna be mental health.
Is what?
Mental health.
He's not coming? Okay, thank you. 21 CF 14558. Mr. Brantz, I'm going to appoint your office in this case.
Yes, Your Honor. I do have a PC challenge as to one of the charges.
Well, first, he's not coming today.
We'll waive the appearance as well, Your Honor. Thank you.
All right, and then go ahead.
As to the count one, agbat on a pregnant person, I believe there's facts in the affidavit that Mr. Robinson knew or should have known. I believe the affidavit states the victim was 9 weeks pregnant, which I think physiologically you may not be showing yet. And they're also a father-daughter as opposed to father-mother or spouse or whoever.
Paramour relationship.
Right. So I don't know if there's enough probable cause to justify a agbat on a pregnant person, Your Honor.
I had the same question, Mr. Brantz, so I'll ask the state. Did you see something that we're both missing?
No, Your Honor, but state would ask for 24 hours to try to correct it.
All right, I'll give you 24 hours. I see about halfway down the affidavit, there's a line that says that she mentioned she's currently 9 weeks pregnant. So I don't know if that's sufficient for knew or should have known.
I think that may have been during the interview with the officer.
Right.
I don't know if that was conveyed to Mr.
Well, that's what I'm saying. She mentioned it to law enforcement, but I don't see anywhere in here where she says she had told her father or anything like that. There is, however, probable cause on count 2. So we'll just reset this for tomorrow to give the state 24 hours on count 1.
We're resetting the whole case.
Yes. Sir, please tell me your name.
Roberto Alegria.
You have a warrant out of Seminole County in 19 CF 1691 for felony petty theft. At this time, there's no bond authorized on that warrant. I'll appoint an attorney to represent you and will notify them that you're here so they can transport you.
Are you turning here for over there?
No, while you're.
They'll work with the public defender there.
While you're here in one.
Gotcha.
Yes, sir. Good luck. Good morning. Please tell me your name.
Laquan Baldwin.
All right, Mr. Baldwin, you're here in several cases. In 21 CF 14549, you're here charged with possession of cocaine, possession of oxycodone, possession of firearm or ammunition by a convicted felon, grand theft of a motor vehicle, dealing in stolen property, resisting an officer without violence, and possession of a concealed weapon by a convicted felon. At this time, I'm going to appoint an attorney to represent you. Mr. Brandt, did you have any motions in that case?
Not at this time, Your Honor.
I agree. I do believe there's probable cause here. Your bond is $1,000 on counts 1 and 2 and 4, $4,000 on count 3, $5,000 on count 5, $500 on count 6, $4,000 on count 7. You can have no contact with any victim, witness, or co-defendant. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, Your Honor.
In 21 CF 14563, you're charged with leaving the scene of a crash with property damage, reckless driving, and fleeing or attempting to elude law enforcement. I'll appoint an attorney to represent you in this case as well. There is probable cause. Hold on one moment. Your bond is $500 on count 1, $100 on count 2, and $15,000 on count 3. Again, you can have no contact with any victim, witness, or co-defendant. You can't possess a weapon, firearm, or ammunition. In 19 CF 16503, you're here for violating your probation. I'm going to appoint an attorney to represent you in that case as well. However, in that case, you'll have no bond at this time. Good luck, sir. Please tell me your name.
Heidi Conception Vasquez.
Good morning. In 18 CF 17830, you're here for violating your probation. Give me one moment. I'll appoint an attorney to represent you in this case. There's no bond authorized. The warrant says that you violated your probation by changing your residence without procuring the consent of your probation officer, by leaving your county of residence without procuring the consent of your probation officer. All right, good luck, ma'am. Please tell me your name.
Jamaica Dixon.
You're here in 18 CF 17532 and 17 CF 12882 for violating your community control in each of those cases. I'll appoint an attorney to represent you.
Okay.
The allegation is that you failed to remain confined to your approved residence as directed.
Yes.
And failed to undergo a drug and alcohol evaluation and failed to undergo a mental health evaluation. So at this time, ma'am, you have no bond on both of those cases.
Okay.
Good luck.
All right.
Please tell me your name.
Summary.
20 CF 5562. You're here for violating your probation. At this time, I'll appoint an attorney to represent you in this case. Hold on, my computer is moving really slowly. You have no bond on this warrant. It alleges that you used intoxicants to excess in violation of your conditions. So, good luck, ma'am.
Thank you.
Yes, ma'am. Please tell me your name.
Amy Waite.
You're here in 2018 CF 12644 for violating your probation. At this time, I'll appoint an attorney to represent you. There's no bond authorized on that warrant. One moment. The allegation is that you violated your probation by committing the criminal offense of driving while impaired in Morrow County, Ohio, and driving while license suspended. All right, so you have no bond. Speak with your attorney about this. I show she's a violent felony offender of special concern as well, counselor. Good luck, ma'am. Please tell me your name.
Latasha Wing.
All right, you have several cases. In 21 CF 14565, you're here charged with possession of MDMA and possession of a controlled substance. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count one, $150 on count two. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription.
I have a prescription, ma'am.
All right, you'll want to show that to your attorney.
They have it, drug court has it, I'm in drug court also. They have the prescription.
All right. Then in 21 CF 887, you're here for violating your probation. I'll appoint an attorney to represent you in this case as well. Oh, it's an on view. At this time, you'll have no bond. In 20 CF 6395, it's the same thing. You're here for violating your probation. You'll have no bond. I'll appoint an attorney to represent you. And at this time, I'm revoking your bond in 21 CF 38.
That's the Osceola? That's Osceola.
It might be. It's petty theft with 2 prior convictions resisting merchandise recovery.
Yeah, that's Osceola.
All right, I'm revoking that bond.
Huh? Yeah, that, I already have transferred.
Yeah, they didn't bring him out yet, so I was just going to ask at the end. Okay.
Oh. Oh.
All right, we're back on the record. It's 10:31 a.m. Same counsel, if you want to put your appearance on record.
Taylor May on behalf of the Office of the State Attorney.
Todd Brands on behalf of the Office of Public Defender.
All right, good morning. Please tell me your name.
Isaiah Antonio McCree.
And why is he here?
This is a juvenile, I believe.
Right, but he is a juvenile, right? That's why I'm asking why he's here. Why is he in the jail and not at the juvenile center?
Your Honor, can you please state your name one more time?
Isaiah Antonio McCree.
I have him here on 2 cases.
I didn't have him on the move up, Your Honor. 1 second.
A warrant in 21 CF 14531. So I'm going to appoint the public defender's office in both of his cases. Mr. McCree, this warrant was issued, so another judge has already found probable cause to charge you with the crime of aggravated assault with a firearm.
Yes, ma'am.
Your Honor, can I inquire about procedure, I guess? May I inquire, Your Honor?
Of me?
Yes.
Well, that's why I'm asking. I guess because the warrant was issued as an adult warrant charging him.
I know they can direct file, but doesn't that mean they have to file an information? Or is an arrest affidavit enough to direct file? Or excuse me, a warrant enough to direct file?
Yeah, it's not a juvenile, it's not a custody order, it's an arrest warrant. So is that why he's here? I mean, it is a really egregious offense.
Yes, Your Honor. If you want to pass him to the end, I can reach out to our juvenile bureau chief before we address him, just to see if she has any other additional information on it. But I do have it as a felony also within our system in adult court. So if you want to pass him to the end, I can reach out to our juvenile bureau chief to see if she has any additional information. Otherwise, we can just address it.
Here it is. So because he's been
I think he's been directed.
convicted as a juvenile, it's a felony for him to possess a firearm until he's 24. Furthermore, he's been charged with firearm charges in at least 5 separate incidents as a minor. So with a 6th, it upgrades the possession of a firearm by a minor charge to a felony. So it's the extensive criminal history, I assume gang affiliation. He's previously been direct filed as an adult in Seminole County for grand theft of a motor vehicle. Therefore, he'll be filed as an adult in all subsequent offenses. And there we have it. Mr. McCree, another judge has already found probable cause in this case. I've appointed an attorney to represent you. I reviewed the affidavit for this warrant. The facts are incredibly egregious. Your criminal history is shockingly long given your age. The court is specifically concerned for the safety of the victim in this case, as well as the citizens of Orange County, given the multiple threats that are alleged that you communicated to the victim using social media and a weapon. I'm looking at the pictures of those threats, Mr. McCree. At this time, your bond on this charge will be $25,000. You can have no contact with the victim or any witness in this case. Do you understand what no contact means?
No, ma'am.
So you can't speak to the victim, you can't contact the victim on social media, you can't send a message through friends or family, you can't send a message on the phone, through a text message. This means no contact at all. Do you understand?
Yes, ma'am.
Furthermore, I'm going to order that you are not allowed to use any social media. That includes Instagram, Snapchat.
Facebook.
What else are the young people using? They don't use Facebook, right?
Twitter,
Facebook, Twitter.
There aren't anything that would fall under social networking.
Right, no social media at all. Hold on, you can't possess a weapon, firearm, or ammunition. Yes, sir, did you have a question?
So I can
Your Honor, to be clear, this is on the ag assault, the 14531.
Yes. Did you speak to your attorney about your question, Mr. McCree?
Yes, ma'am.
All right, so you don't have a question for me about it?
No, ma'am.
All right. Are there any other conditions the state would request in that case?
Your Honor, I know you did a no contact with victims or witnesses. State would ask also for a not allowed within a certain amount of feet.
What?
Not allowed within a certain amount of feet.
All right, I'll order that you're not allowed within 1,000 feet of the victim's residence or place of employment. Do you understand that?
I don't know who it is.
State, can you please tell us who the victim is?
Yes, Judge. One second, I closed the tab. The alleged victims and witnesses are Katoya Golding, Jaquacia Golding, Elenika Williams, I believe that's it, Your Honor.
All right, in 21 CF 14538, you're here charged with possession of a concealed weapon or firearm by a convicted delinquent, an unlawful possession of a firearm. At this time, your bond is $5,000 on count 2, $150 on count 1. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand that?
Yes, ma'am.
There's probable cause. I'm appointing an attorney. Did this take place at Jones High School, Miss May, or
I believe it
later?
I believe it originally began at Jones High School, and then they left the school.
Oh, it's okay.
And
do you go to Jones High School?
No, ma'am.
All right, you're not allowed to return to Jones High School for any reason. Do you understand?
Yes, ma'am.
You can't have contact with any co-defendant in this case. Any other conditions the state would request in this case?
No, Your Honor.
All right, Mr. McCree, you need to call your attorney right away. Do you understand?
Yes, ma'am.
All right, good luck, sir. Yes. Please tell me your name.
Tyrone Sherman, Dallas.
Sir, you're here in 21 CF 9807. An information was filed charging you with petty theft with 2 prior convictions. Your bond is $500. You can't return to the scene or have contact with any victim or witness in the case. Do you understand?
Yes, ma'am.
And I'll appoint an attorney to represent you.
Just said that.
a bond out today? I don't know. I don't know.
You got a bond. Dr. Bonston, okay?
Is this Spanish next?
Yes. Yes, ma'am.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Are you not going to put the headset on him? Good morning. If you could please connect with the headset.
Yes, Your Honor, I'm confirming at the moment. I'll let you know, Judge.
Thank you.
Your Honor, the interpreter can confirm the defendant is able to hear through the headsets.
Thank you. Good morning, sir. Please tell me your name.
Carlos Alejandro Robles Curbelo. Curbelo. C-U-R-B-E.
Carlos Alejandro Robles Curbel.
Sir, you're here in 19 MM 1447 because a capias was issued for your arrest for failing to appear for a pretrial conference on a charge of petty theft. The bond authorized is $500. I'll appoint an attorney to represent you.
There was an offer to resolve, Your Honor. Although I didn't get the chance to speak due to the language barrier. It is a withhold credit time served and
I don't know if I'll accept that. I show that he has 2 prior failures to appear. Were either of those on theft cases, Ms. May?
I did look this up, Your Honor. They were not on theft cases. He was put in PTD and was rejected from PTD earlier this year. 2 prior failures to appear, I believe, was a duelist. One was dismissed and one was a TR that was adjudicated guilty.
And one was a what?
TR case.
Traffic. I'm sorry. All right. Mr. Robles Carvello.
Your Honor, if I may.
Yeah, go ahead.
If you are considering accepting that plea, could I hand him a Spanish plea form to review?
Yes.
Be at the end of city county ordinances.
Here's what we're going to do. The public defender is going to give you a plea agreement that's in Spanish. I'd like you to review that. It explains the rights you'd be giving up if you enter a plea of guilty or no contest. I'm going to give you a few moments to read that, and then I'll recall your case, and we'll discuss whether you want to enter a plea today. Do you understand? Did he say yes?
Yes, he did, Your Honor.
Okay, we'll recall his case.
Thank you, Your Honor.
Yes, sir. Good morning, sir. Please tell me your name.
Trinidad Leiva Cuagua. Trinidad Leiva Cuagua. Trinidad Leiva L-I-Y-B de vaca A Cuagua C-U-A-H-U-A.
Trinidad Leiva Cuajua.
Sir, you're here in 21 CF 14545, charged with criminal mischief, damage greater than $1,000. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. With special conditions, you cannot return to the Firestone located at 4436 Curry Ford Road. You can't have contact with any victim or witness in this case. Do you understand?
Sí.
Yes.
All right, good luck, sir. Is that all we have for Spanish at this time? All right, thank you for your service, Mr. Interpreter. We're going to call you back in just a few moments.
Yes, Your Honor. Have a good morning.
You as well.
The Leon bonded. Virginia Pendergrass bonded. Andrew Scott is medical.
21 CT 579.
Are we on arraignments?
Yes. Mr. Brandt, I'll appoint your office.
We'll waive the appearance and enter a plea of not guilty, Your Honor.
Division 61, pretrial conference, December 10th at 1:30 p.m., courtroom 6B.
That was from Ms. Prendergast?
No.
Mr. Scott, Mr. Andrew Scott.
Prendergast bonded.
Sir, please tell me your name.
Araya Sirak Ogba Mikhail.
21 7291. You're here charged with trespass on property other than a structure or conveyance. Mr. Brandt, your office represents him.
Yes, Your Honor. We'll enter a plea of not guilty. Also, I believe he's been in jail since October 14th. I don't know if you're inclined to set bond at ROR or change bond to ROR.
What is his bond currently?
I'm not sure, Your Honor.
I am not. I don't have enough information about this case to do that. You're going to have to file a motion, counselor.
Division 85, pretrial conference, November 29th at 9 o'clock, courtroom 4A.
Sir, please tell me your name.
Herman Arroyo.
21 7857. Mr. Brandt, your office represents him for criminal mischief.
Yes, Your Honor. We'll enter a plea of not guilty.
I need 1 second. It doesn't have a division on it.
Hold on, that one doesn't have a division on it.
Division 62, pretrial conference, November 29th at 8:30, courtroom 9B.
Clarence Dorson is medical.
21 7431. Mr. Brandt, your office represents him as well.
We'll waive the appearance and enter a plea of not guilty.
Division 62, pretrial conference, November 29th at 8:30, courtroom 9B.
Please tell me your name.
Stephanie Lampo.
21 7328. Mr. Brandt, your office represents her in this petty theft.
Yes, Your Honor. I didn't see her with the rest of the arraignments. Could I have a moment to speak with her?
Yes.
There is an offer from the state. Thank you, Your Honor. I believe she might qualify for a pretrial diversion, so we would enter a plea of not guilty, and then have her work with our office to hopefully resolve that.
Division 82, pretrial conference, December 6th at 10:30, courtroom 10B.
I'm also not sure if she would qualify for pre-trial diversion as she has an open felony case.
Can you repeat the next court date, Madam Clerk? I'm sorry.
December 6th at 10:30, courtroom 10B, Division 82.
Thank you, Madam Clerk.
Please tell me your name.
Emmanuel Lewis.
2019 MM 8314 BO. You're here charged with resisting an officer without violence and trespass on school grounds. Mr. Brands, your office represents him.
Yes, Your Honor, we'll enter a plea of not guilty here as well.
Division 82, pretrial conference, December 6th at 10:30, courtroom 10B.
Good luck, sir.
An attorney appointed to.
Please tell me your name.
My name is Jimmy Logre.
21 MM 492. Mr. Brands, your office represents him in this trespass.
Yes, Your Honor, we'll enter a plea of not guilty.
Division 80, pretrial conference, December 20th at 9 o'clock, courtroom 9C.
Lourdes Perez is medical.
21 MM 7395. Mr. Brands, your office already represents him.
Yes, Your Honor, we'll waive the appearance and enter a plea not guilty.
Division 83, pretrial conference, November 22nd at 8:30, courtroom 6C.
Ryan Correa is medical.
21 MM 7588. Mr. Brands, your office represents him as well.
We'll waive the appearance and enter a plea not guilty, Your Honor.
Division 81, pretrial conference, December 10th at 9 o'clock, courtroom 4E.
Good morning, sir. Please tell me your name.
Gary Jenny.
21 MO 1158. Sir, you're here charged with disorderly conduct. Mr. Brands, your office represents him.
Yes, Your Honor, we did have an offer from the state, a withhold of adjudication, credit time served, court costs, and I believe a $10 filing fee. I went over those terms with Mr. Tenney, as well as gave him a plea form to review, and I believe Mr. Tenney wishes to resolve today.
Please raise your right hand, Mr. Tenney.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, I do.
Thank you.
All right, sir. You can put your hand down. You had a chance to speak with your attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
Yes, ma'am.
Do you have any questions for me about them? Did you have a chance to review that form in front of you? It's the plea form, and it explains those rights again.
Yes, I did.
All right, sir. Do you have any questions about that?
Nope.
You understand that if you're not a U.S. citizen, you can be deported? And if you're on probation anywhere, entering a plea of guilty or no contest today could violate that probation. All right, sir, at this time, how do you wish to plead to the charge of disorderly conduct?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for 36 days that you've spent in custody. Sir, I have to order that you pay court costs and a $10 filing fee. I'll give you a year to pay those.
What does the court cost be?
It's almost $300. It's two something. It's $323 total. Good luck, sir. You have 30 days to appeal in writing.
Okay.
Good morning. Please tell me your name.
Luis Augusto Hernandez.
21 MM 7946. You're here charged with trespass and conveyance. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. With special conditions, you can have no contact with the victim in this case. Are there any other conditions the state would request?
Your Honor, state would also ask for no contact with any potential co-defendants.
You can have no contact with any co-defendants in this case. And at this time, I'm revoking your bond in 21 CF 2273.
Your Honor, would you consider revoking and doubling?
Why?
Just because the new law violation is an alleged trespass, as opposed to a repeat offense on the charges that he's out on bond at, such as having drug paraphernalia or resisting officer.
I don't know why this isn't charged as a grand theft. He's in possession of a recently stolen vehicle.
Yes, Your Honor, that's why the state did not convey an offer at this time, and believes that if it is filed on, it likely will be filed on as a grand theft motor vehicle.
Also, Your Honor, I don't know if we're appointed in the out on bond case, and if not, can we be appointed?
I will appoint you in that case.
I'm not sure if the 21 CF 2273 is an accurate case number. I have that coming back to Mr. Morrell. Does anyone?
That's a Miller County case.
Thank you.
Based on your argument, Mr. Brantz, and his limited criminal history, I will do that. I'll revoke and double each of those bonds. And all of the original conditions in that case will still apply.
I believe count 1 was originally 2,000. I believe count 2 was originally 5, and count 3 was originally 5.
Count 3, I'm sorry.
2,500, 500.
So it'll double that. Good luck, sir. Right. 4,000, 1,000, and 1,000. Please tell me your name.
Charles Hall.
21 MM 7930. You're here charged with criminal mischief. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can have no contact with any victim, witness, or co-defendant, and you can't return to the scene for any reason. Do you understand?
Yes, ma'am.
Good luck, sir.
So 500. What if I don't have $500?
So you can talk to your attorney. They can file a bond motion in front of the trial judge to reduce that amount.
Okay. And who I talked to about, because this is the affidavit that was written up by the officer is skewed. Okay.
So, sir, we're just here today about probable cause and bond. If you think you have some defenses to this, you want to call your attorney right away so that they can talk to the prosecutor and negotiate on your behalf or file a motion in front of the trial judge.
Okay, so when do I go and try to post bond?
So you can post bond at any time now.
So this isn't the judge, though, see?
Good luck. Please tell me your name.
Nicholas Jacobs.
21 MM 7944. You're here charged with resisting an officer without violence and soliciting without a permit. There is probable cause. Was there an offer?
Yes, Your Honor. State did convey an offer of an adjudication credit time served.
Your Honor, I believe we do have some defenses to these charges. I would just have you, if possible, set, as Mr. Jacobs is transient and doesn't have any money to bond out, if you would consider a release on own recognizance, pending these pending our work on this case.
Your Honor, state would object in regards that he had 2 prior failures to appear, both that were semi-recently. State is concerned that he would not show back up to court if released ROR.
The court is also concerned about threatening law enforcement officers with death. So I'll not release him on his own recognizance at this time. I will stay your bond at $500 on count 1, $100 on count 2. Sir, you can't possess a weapon of any kind. Do you understand?
Yes, ma'am. I'm not sure if you're aware of the facts. I didn't ask for a public defender to represent me. I wanted to represent myself. The whole entire situation between me and that officer is on camera from Sand Lake Road and International Drive. I suggest y'all look at that before you give me a say I'm guilty or not guilty. Because
Sir, listen, I'm not saying you are guilty. I'm not even saying the state can file the charges. The only thing you're here for today is for me to review to determine whether there's probable cause and then set your bond. We're not having an evidentiary hearing here today. There's no trial. At this time, the state hasn't even made a filing decision. So probable cause is just cause to believe you probably did something. That's why we're here today.
I understand that.
So, hold on, let me finish. Based on the affidavit, which is the only information I have right now, there is probable cause. Now, if there's a video, the state will review that later. Your attorney will get that. At another stage, if you want to represent yourself, you can do that. But for today, I need to appoint the public defender to represent you because the Supreme Court of Florida issued an administrative order because of the pandemic. We're supposed to appoint the public defender in all cases. But at any time, you can file a motion in front of your trial judge to remove the public defender.
See, I'm not familiar with everything. I have lawyers and stuff aware of my situation. They just weren't able to get here fast enough.
Okay, so if you're going to hire an attorney, that's the same thing. They can file a motion to replace the public defender. This is just a temporary thing.
Yeah, I'm just letting you know. I don't have money or really a way to bond out at this time. I've literally be sitting here on a not guilty charge for no fucking reason. Excuse my language. I didn't mean to cuss. That just was natural. Sorry.
Call your attorney right away, sir. They can file a motion to reduce your bond in front of the trial judge.
I'm so confused right now. I don't know what to say or do. I wish that was on the street.
All right, good luck, sir. So we're calling the interpreter back now?
Yes,
Okay.
sir.
Good morning, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Good morning, thank you. If you could please connect with the headset.
Sí.
Interpreter is connected to the podium, Your Honor. Thanks.
Sir, please tell me your name again.
Carlos Alejandro Robles Curbelo.
All right, sir, you're here in 19 MM 1447. A capias was issued for your arrest for failing to appear for pretrial conference on a charge of petty theft. The state conveyed an offer. If you want to tell them what that is, Mr. Brands.
Offers a withhold of adjudication, credit time served, and no return.
Are you interested in accepting the state's offer here today?
¿Me podrías repetir? Disculpa.
I'm sorry, could you repeat?
So offer to resolve is a withhold, credit time served, and no return to the TJ Maxx at 5476 Fun Spot Way.
Bueno, honestamente no volví al establecimiento. Ahora que estoy hablando, yo no fallé a la corte porque no quise ir, sino porque simplemente yo le estaba llevando un seguimiento por internet al caso
All right, sir, I need you to speak in short sentences for the interpreter.
Well, I didn't go back to the scene, to the establishment in question here. And the reason why I didn't appear was not because I did not want to appear. What I'm saying is that I was actually following up on this case via online.
So, sir, another judge issued this capias. I cannot change it. If you think you have a defense to not going to court, you can present that to the trial judge. That judge issued a capias with a bond of $500. So if you want to not enter a plea of guilty or no contest today, you can enter a plea of not guilty and talk to your attorney about defenses that you have to both the petty theft and to the capias, the failure to appear.
You want to keep working with your attorney and go to the next court date with your attorney to resolve? It's a $500 bond. Right?
Ese es el problema, yo no cargo mi tarjeta, yo no cargo ni siquiera mi dinero.
Well, that's the problem. I don't even have any cards with me. I don't have any money on me.
Sure, you don't have to have it with you. You can contact friends and family and work with a bondsman
In our office as well.
in your attorney's office.
Oh, I'm sorry. We can just bond today and you can work with your attorney.
You can enter a plea of not guilty. You'll have a bond of $500 and call your attorney right away, okay? You understand?
Sí.
All right. Good luck, sir.
Thank you.
Thank you.
Thank you.
All right, I believe that's all we have for the interpreter.
Oh, well, Your Honor.
Thank you.
Well,
Please tell me your name.
Erica Ambo.
21MM7280. You're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of petty theft. The bond authorized is $250. I'll appoint an attorney to represent you. Good luck, ma'am.
Thank you.
Sir, please tell me your name. I'm sorry, I couldn't hear you.
I believe it came in as John Doe, Your Honor.
Yeah, I had someone in between.
Abdirashad Hassan. Abdirashid Hassan.
I don't know.
Is Hassan here?
What happened to Mr. Hassan?
He's an ex.
That's him?
No, he's out there.
I guess because his last name was Doe and now it's Washington. Alphabetically.
Oh, I have Hassan. Okay, all right. So you're Mr. Washington. 21MO1299. Sir, you're here charged with violating state misdemeanors. Was there an offer?
Not at this time, Your Honor.
All right, sir, there is probable cause. I'll appoint an attorney to represent you. Your bond is $250. Are there any other conditions the state would request?
Your Honor, state would ask for a no return to the Target and the TJ Maxx on West Grant.
I will order you're not allowed to return there. At this time, I'm revoking your ROR in 21MM 7526.
This is condo, right?
It is, yes.
Your Honor, would you consider setting a monetary bond?
One moment.
It's okay.
Your Honor, that out on bond case allegedly occurred 10/23. And this offense, even though it's charged as a state misdemeanor, is arguably a petty theft as well.
Right.
Arguably about less than about 2 weeks later.
Your Honor, it's a nonviolent offense against property, not person. I would just have to consider that as well.
I'm also looking at his history, counselor. It looks like hold on one moment. He has 4 failures to appear, several prior theft cases. He's out on bond for a theft case. All right, I'll set that bond at $500 with a no return. Good luck, sir.
Out on bond case, Judge?
Yes.
And the other case was raised to 250,
Yeah.
because I have 150 on here.
I thought I said 500. Did I say 250?
On the new case?
Yeah.
You said
250.
I said 250? Okay, it's 250.
and the out on bond case was
500, yes. Please tell me your name. What's your name, sir?
Abdul Rashad, last name Hassan.
21 MO 1300. You're here charged with open container of an alcoholic beverage and 2 counts of violating state misdemeanors. Was there an offer?
Yes, Your Honor. I've been authorized on this behalf of the city to offer a withhold credit time served.
Your Honor, I did speak with Mr. Hassan. I did also convey that offer as well as a plea form to review, and I believe Mr. Hassan wishes to result today.
Sir, please raise your right hand.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Accent.
Thank you.
All right, sir. There is probable cause here. You had an opportunity to speak with an attorney about the rights you'd be giving up if you enter a plea of guilty or no contest. Do you understand those rights?
No consent.
I couldn't hear him.
No consent.
Do you understand?
Yes, Your Honor.
All right, sir. Do you have any questions for me about those rights?
No questions, Your Honor.
I just need him to get closer to the microphone.
No.
Thank you. Sir, you had the opportunity to review that form in front of you. That's the plea offer. It also discusses those rights. Do you have any questions for me about that form?
No.
You understand if you're not a U.S. citizen, you could be deported?
Yeah.
You understand if you're on probation anywhere, this plea could violate that probation?
Yeah.
All right, at this time, sir, how do you wish to plead an open container of an alcoholic beverage and 2 counts of violating state misdemeanors?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the
2 days.
2 days you've been in custody. What else was it, Ms. May?
That was it, Your Honor.
I'll order that you pay court costs, and I'll give you a year to do that. Good luck, sir.
Thank you. Thank you.
Yes, sir, you have 30 days to appeal in writing. Please tell me your name.
Nicholas Trigno.
Sir, you're here in 21 CT 1969 and 1970, charged with driving under the influence of alcohol and driving while license suspended. There is probable cause. Your bond on the DUI will be $500. Your bond on the driving while license suspended is also $500. With special conditions, you can't possess or consume any alcoholic beverages or any controlled substance without a valid prescription. You'll be subject to drug and alcohol screens while you're out on bond. You can't drive without a valid Florida license. You also have a violation of probation out of Hillsborough County in 2014220. You'll have no bond on that. I'll appoint an attorney to represent you in all of your cases, and we'll notify Hillsborough County that you're here. At this time, I'm revoking your bond in 21 CF 12939. Good luck, sir. Sir, please tell me your name.
Jeffrey Berry.
21 CF 14553. You're here charged with possession of cocaine and drug paraphernalia. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on count 2. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. In 21 CF 14554, you're here charged with driving while license revoked as a habitual offender. There is also probable cause for that charge. I'll appoint an attorney to represent you. Your bond is $2,500. Sir, you can't drive without a valid Florida license.
A moment, Your Honor. Thank you, Your Honor.
Good luck, sir. Please tell me your name.
Michael Cintron.
Sir, you're here in 21 CF 14551, charged with grand theft of a motor vehicle and trespass and a conveyance. There is probable cause. I'll appoint an attorney to represent you. Your bond is $3,500 on count 1, $100 on count 2. You can have no contact with any victim, witness, or co-defendant. You can't return to the scene for any reason. In 21 CF 14555, you're charged with fleeing or attempting to elude law enforcement with lights and sirens activated. There is probable cause. I'll appoint an attorney to represent you in this case as well. Your bond is $15,000. And then in 21 CF 1252, at this time, I'm revoking your bond. Good luck, sir.
Rowan Combs, his behavior.
Thank you.
You have an open. FPD room. You gotta call us to talk to her. It's revoked, yeah.
That's 21 CF 14561. Mr. Brandt, I'm going to appoint your office to represent him.
We'll waive the appearance, Your Honor.
All right, there is probable cause. Give me one moment. His bond is $1,000 on count 1, $3,500 on count 2, $100 on counts 3, 4, and 5, and $1,000 on count 6. Cannot possess or consume any controlled substance without a valid prescription. Cannot have contact with any known drug dealers. Cannot return to the scene. No contact with any victim. At this time, I'm revoking his bond on 21 CF 623. Good morning. Please tell me your name.
Geneva Dixon.
You're here in 21 CF 12841. A KPS was issued for your arrest for failing to appear for arraignment on a charge of petty theft with 2 prior convictions. The bond authorized is $1,000, and I'll appoint an attorney to represent you. Good luck.
Okay.
Please tell me your name.
Jamisha Graves.
21 CF 14547. You're here charged with possession of an anti-shoplifting device, use of an anti-shoplifting device, and petty theft, retail. I'm going to appoint an attorney to represent you in this case. There is probable cause. Give me one moment. Your bond is $1,000 on count 1, $1,000 on count 2, $500 on count 3. You can't return to the outlets at 8200 Vineland Avenue. Do you understand?
No.
You can't have contact with any co-defendants, victims, or witness in this case. Good luck. Please tell me your name.
Rodolfo Gutierrez.
All right, you have a couple of cases here. 21 CF 14552. You're here charged with grand theft and battery. There is probable cause. I'll appoint an attorney to represent you. One moment. Your bond is $5,000 on count 1, $100 on count 2. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon of any kind, firearm or ammunition. You can't return to this scene for any reason. You can't possess or consume any alcoholic beverage. You'll be subject to random alcohol screens. In 21 MM 275, you're here charged with 5 counts of resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you in this case as well.
Your Honor, state has no objection to giving bonds on count 1 and then subsequent bonds on the additional 4 charges.
I'm sorry, say the last part again.
State has no objection to you giving a standard bond on count 1 of this case and then treating the rest as subsidiaries or RORing as to them.
I'm not inclined to do that. Thank you. Let me rephrase that. I'm not inclined to ROR him. Count 1, your bond is $500. Counts 2, 3, and 4, and 5, your bond is $100. You can't possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes.
Good luck, sir. Please tell me your name.
Kenneth James Hardy.
21 CF 1087. You're here because a capias was issued for your arrest for failing to appear for a trial management conference on charges of burglary of a structure, petty theft, and criminal mischief. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck.
Yeah, those are.
Right there. Yes, they do.
Good morning. Please tell me your name.
Mark A. Henson.
Sir, you're here in 21 CF 14529. A warrant was issued for your arrest, charging you with criminal mischief, damage greater than $1,000. Another judge has already found probable cause in this case, and I'll appoint an attorney to represent you. The bond authorized is $1,000. I'll stay that bond. With special conditions, you can have no contact with any victim or witness in this case. Give me one moment.
How can you see it? I ain't got no glass.
There's a public defender's number right here.
Just make sure that you write.
Ma'am, can I ask you a question?
Sir, you can ask anything you wish. I want to make sure you understand everything you say is being recorded and can be used against you later. Do you understand that?
Yeah.
Okay.
What's this out-of-state warrant of arrest? What the heck is that? That's what it says on this thing here.
I don't know what that is. I don't see that.
That's what it says, original offense, if known, a BOP, fugitive, FTA, and it says out-of-state too.
Your Honor, I believe on the warrant affidavit, that black box that says.
I don't understand none of this.
It
It
comes,
says it's a what?
the black box on the affidavit that comes in, it says it's an out-of-state warrant arrest, just indicating that it was a warrant, that PC's already been found. I believe that's what, Mr. Henson is referring to.
What's she talking about?
She said all the forms.
It's indicating what, Miss May?
May I approach?
Yeah, I can't really hear you, so.
They all say.
Oh. I think that's confusing. Right, I see. Okay. I think it's just saying that it is a warrant. I don't know why it says out of state. It's not an out of state warrant. It's an Orange County warrant.
I've been going through a lot of problems back here in this jail, back here in these offices.
I believe you. What I want you to do is call your attorney right away. See the phone number on that green piece of paper?
Which one is it? That one?
Yes, sir. There's a phone number. Call your attorney right away.
Well, I can't make bond because I ain't got no money to make bond with.
Oh, and also do not return to the scene. You're going to call your attorney and they can file a motion in front of the trial judge for you, okay?
Ah, here you get out of here.
All right, good luck, sir.
Don't pull me around like I'm nothing.
Sir, please tell me your name.
Curtis Howell.
You're here in 21 CF 14559, charged with possession of cocaine. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Good luck, sir.
Okay, that's for R&R, but I work out of the labor pool. I can't afford that.
All right, just a moment.
Thank you.
Mr. Brands, did you want to argue for a lower bond?
Yes, as he's underemployed, I would say, and the money is indefinite, or unsure when more money is going to come in, I would, and as I'm reading the criminal, he works for labor pool. I would ask for ROR as well.
What says the state?
Your Honor, state would object at this time, given one, he's recently pled to a duelist. Two, he has a pretty extensive out-of-state history, which includes failures to appear and violations of probation and parole violations, showing an inability to comply with the court orders. In addition to Florida arrests and convictions, including VOPs and violations of injunctions as well. Again, showing an inability to comply with court orders, state's concerned that he would come back to court if needed, given that he did have prior failures to appear out of state.
Your Honor, he's also a veteran of the U.S. military, and if you do set a monetary bond, I would just have you set the lowest at 100.
So
Fairly lengthy
if
violence.
he's here for the next 32 days, because he can't post the bond, and the defense files a motion to release him on his own recognizance, is the state going to ask me to grant that motion because you have to send it to FDLE?
I'm not sure, Your Honor. I would not be the ASA filing on this case.
In what possession cases is the state not asking me to grant that motion?
Some of them we get, I mean, Your Honor, we have like 30-something felonies today. Usually about half of them tend to be drug charges. We don't usually have that many ROR motions on all of them. FDLE gets some of them back to us, just not all. So I'm unsure. I can't speak to FDLE and how fast they get it back to us. I'm just concerned regarding his history of drug offenses, violent offenses, VOPs, failures to appear, and parole violations. And arguably doesn't have strong community ties to the area due to having a lengthy out-of-state history and not being employed here.
I do see out-of-state convictions. He has 3 violations of probation.
Can Mr. Holland be heard, Your Honor?
He can be. Mr. Holland, I want to make sure you understand everything you say is being recorded and can be used against you later. Do you understand that? All right, I want you to raise your right hand to be sworn.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
Yes, I do.
Thank you.
Go ahead, sir.
I mean, them old cases, I mean, I'm a changed man now. I've been staying in Florida for like 15 years. So, I mean, now I'm working through the labor pool. I had a regular job, but the pandemic, I got my daughter down here from Maryland. She's 11 years old. I just made a bad decision. I'm going to show up for court. I just can't afford to get out, either or.
All right, sir.
See it on your heart to let me out. I'm not going to run nowhere. I mean, I stay on 28 South Hudson Street. I mean, I work at the labor pool, so I do the best I can.
I appreciate that, sir. I also appreciate that according to the facts in the affidavit, you were cooperative. I do share the state's concern. It does look like you have some prior things like violations of probation, which just raise the concern about you returning for court, which is part of the purpose of a bond. However, I am going to reduce this bond. Sir, I'm not going to release you on your own recognizance. I understand that's what you're asking me to do, but I'm going to require that you post a $250 bond. You have an attorney. They can file a motion in front of the trial judge to lower that bond even further. I don't know if the judge will do it, but they can file a motion for you. But I reduced the bond significantly. Good luck, sir. Yes, sir. Sir, please tell me your name. 21 CF 14122. You're here because a warrant was issued for your arrest, charging you with child abuse. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Is he on probation?
He's not.
But he was released from DOC for manslaughter in 2019? All right, does either side wish to be heard on bond?
As to the defense, Your Honor, just a reasonable bond. He is entitled to it on this charge.
Ms. May, anything from the state?
Your Honor, he is otherwise entitled to a reasonable bond. However, the state does share your same concerns regarding this as a violent offense. And he was recently released from DOC with a violent offense, as well as other convictions of violent offenses and history of violent offenses. And out of state, I believe he also has an out of state history from New York as well as Connecticut. So in addition to a violent criminal history, he has 2 failures to appear as well as out of state history, potentially showing that he doesn't have lengthy ties to this community. So state would have you take all that into account when setting bond.
Is this a PRR offense?
It is, Your Honor.
Yeah, I thought so. All right, sir, at this time, your bond is $25,000. You can have no contact with the victim in this case. Do you understand what no contact means? I can't hear you.
Yes.
You can't possess a weapon, firearm, or ammunition. You can't have any contact with any minor child under the age of 18. Any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Please tell me your name.
Veronica Isabella, ma'am.
21 CF 14557. You're here charged with destruction of evidence, possession of cocaine, and possession of MDMA. At this time, I'm appointing an attorney to represent you. Mr. Brantz, did you wish to be heard?
Your Honor, I would make my usual argument as to these cases. A lot of the evidence was recovered, so I would just have you find PC for attempt on count one.
Did you say find no PC?
No, I was saying fine PC for attempt on count one.
All right, what says the state, Ms. May?
Your Honor, I believe this one is an actual destruction of evidence for what defense is arguing is a tampering when all the evidence is obtained. In this case, all the evidence was not obtained. It is alleged that she was spitting constantly out of the roll down window, and law enforcement observed a large amount of white powder and green leafy substance all over her facial area, clothes, and rear of the patrol vehicle, arguably insinuating that she was trying to spit it out of the car. So all the evidence was definitely not obtained in this case. Therefore, I believe there is PC for, as it's currently charged, the destruction of evidence.
I think there is, Mr. Brantz. I read it a couple of times because I wanted to make sure I understood, but some things were recovered, but not all. I think it would go to, there would have been a lot more of it.
That's right.
But I understood your argument because I had the same thought. Like I said, I read it 3 times to make sure. All right, ma'am. There is probable cause. At this time, your bond is $1,000 on count 1, $1,000 on count 2, $1,000 on count 3. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. And at this time, I'm revoking your bond in 21 CF 8094.
What does that mean?
So you have a bond on your new case, but because you were out on bond for a criminal offense and got arrested for another one, I've revoked that bond. So you'll sit at no bond until your attorney files a motion.
Okay, yes, ma'am. And what?
I'll appoint the PD on that. Please tell me your name.
I'm Scott Jernigan.
In 21 CF 12644, a warrant was issued for your arrest, charging you with burglary of a conveyance and petty theft. Another judge has already found probable cause. Your bond is $3,500 on count 1, $100 on count 2. I'll appoint an attorney to represent you. The conditions are you can have no contact with any victim or witness in the case. You can't return to the scene. You can't possess a weapon of any kind, firearm, or ammunition. In 21 CF 12646, you're here charged with armed burglary of a conveyance with a firearm and grand theft of a firearm. Another judge has already found probable cause. I'll appoint an attorney to represent you. Ms. May?
Your Honor, given that count 1 is a punishable by life offense, state's asking that you hold him no bond pending an Arthur hearing.
I didn't. Hold on. Can I have a moment to confer, Your Honor, before
Yes.
responding?
All right, sir.
Your Honor, we have no argument, but Mr. Jernigan is entitled to a full Arthur hearing with his attorney present.
He is. So at this time, you'll have no bond on count 1. Your bond on count 2 will be $5,000. You can't possess a weapon, firearm, or ammunition. You must surrender the firearm within 24 hours of your release. You can't have contact with any victim, witness, or co-defendant in this case. Good luck, sir. Please tell me your name.
Ebony Siddiqua Griffin, Sabrina Johnson.
I'm sorry, one more time.
Ebony Griffin. Sabrina Johnson is the name I used 2006.
All right, so are you also known as Sabrina Johnson?
I only used it one time.
So that's not your name?
No, it is not.
She stated her AKA was Ebony Griffin.
No, that's my real name, ma'am.
Thank you.
All right, well, ma'am, in 2006 CF 9908, a capias was issued for your arrest for failing to appear for court on charges of aggravated assault with a deadly weapon, resisting without violence, carrying a concealed weapon, possession of drug paraphernalia, and loitering or prowling. There's no bond authorized on that capias. I'll appoint an attorney to represent you. Ms. May, are you making a note about the name?
Your Honor, I have cases. Yes, Your Honor.
1 through 3, I did not do whatsoever.
Yes, Your Honor. I
Sorry.
did make note of it for that ASA.
Okay. All right, and ma'am, I couldn't hear you, I'm sorry.
I don't think she had anything to say on record, Your Honor.
All right, good luck, ma'am. Please tell me your name.
Rasheem Jones.
Sir, you're here in 21 CF 14530, charged with grand theft of a motor vehicle. There is probable cause. I'll appoint an attorney to represent you. Your bond is $5,000. You can have no contact with any victim, witness, or co-defendant. You can't return to the scene for any reason. Do you understand? Sir, I asked you a question. Mr. Jones, did you hear me?
Yes, ma'am, but no, I do not understand. When I was arrested, my bond was $1,000.
I changed it. Sir, I'm looking at your criminal history. I see that there are prior failures to appear. You have several convictions for grand theft. The most recent one I show is in 2020. And one of the purposes of bond is to secure the presence of the defendant for future court dates. At this time, the court is a little bit concerned about that. So call your attorney right away, sir. Please tell me your name.
Lambert Richard.
A warrant was issued for your arrest in 21 CF 13864 for grand theft, $20,000 or more, burglary of a structure, dealing in stolen property. Another judge has already found probable cause.
Your Honor, count 4 through 100
Yeah.
are all F3s, the false statement of verification.
Hold on one moment.
Would you consider setting bond in one count and ROR in the 99 other counts?
I think that's what's in the warrant, isn't it?
I believe so, Your Honor.
It's 100 charges. Yeah. I will do that. So on count 1, your bond is $2,000, count 2, $2,500, count 3, $2,000. And then counts 4 through 100, all set at ROR. You can have no contact with any victim, witness, or co-defendant. You can't return to the scene for any reason. Any other conditions the state would request?
You said no contact with victim, witness, co-defendant, and no return?
Yes.
I believe that was all that was on the warrant, Your Honor.
All right, good luck, sir. Please tell me your name. In 21 CF 14568, you're here charged with sale or delivery of fentanyl, methamphetamine, and possession of fentanyl and methamphetamine. There is probable cause. I'll appoint an attorney to represent you. One moment. Your bond on counts 1 and 3 is $15,000. Counts 2 and 4 is $1,000. You can have no contact with any known drug dealers. You can't possess or consume any controlled substance without a valid prescription. Good luck, sir.
Mr. Marshall bonded.
Thank you. Please tell me your name.
Kenneth Miller.
All right, Mr. Miller, you're here charged with possession of cocaine. I'm going to appoint an attorney to represent you in this case. There is probable cause. Give me one moment. Did you wish to be heard on anything, Mr. Brandt?
This is one of those cases that I'm always concerned with, but I would just have you set a reasonable bond, especially after the last case. Although he was a veteran, just consider the similar circumstances in setting bond here as well, perhaps another $250.
What says the state?
Your Honor, I believe the bond is reasonable. He arguably has at least 15 felonies, 25 misdemeanors, a recent failure to appear, and then 25 other unknown dispositions. His Florida conviction history doesn't seem drug related. It seems mostly violent related. And the last note is that he was released from OCJ 9/3/21. So the arrest history seems fairly lengthy and rather happens quite a bit. It notes that it's the 4th arrest so far this year.
All right, sir, I'm going to set your bond at $250. With special conditions, you can have no contact with any known drug dealers, and you can't possess or consume any controlled substance without a valid prescription. Do you understand?
Give us a call. Bondsman might ask for $25.
It was a crime. I'm not sure.
Bondsman might ask for $25.
Good luck, sir.
Give us a call.
Okay, when I get out, if I get out, I got my bond, $25.
That's usually, yeah.
Hmm?
Yeah.
Okay.
And then you give us a call, right? And we'll help you out. All right.
Please tell me your name.
Hello, ma'am. My name is Jonathan Gumbo.
Good morning, sir. You're here in 21 CF 9173 because a capias was issued for your arrest for failing to appear for pretrial conference on charges of robbery by sudden snatching, tampering with a witness, and battery with a prior battery. There's no bond authorized on that warrant, on that capias, and I'll appoint an attorney to represent you. Good luck.
All right, thank you.
Please tell me your name.
Jimmy Rodriguez.
Sir, you're here because a warrant was issued for your arrest in 21 CF 1409, charging you with aggravated battery with a weapon and aggravated assault with a firearm. I'm going to appoint an attorney to represent you. Another judge has already found probable cause here. Does either side wish to be heard on bond?
As to the defense, just a reasonable bond, Your Honor.
Anything from the state, Ms. May?
Your Honor, I believe the weapon used within this warrant was it seems like an expandable baton. It seems almost like a police baton is what I'm imagining. And I believe the victim was struck in the head and arms. He otherwise is entitled to a reasonable bond. It would just have you take into account the weapon that was allegedly used, as well as his criminal history. While he does have 2 prior failures to appear, however, they used him from a long time ago. However, he was recently released from DOC for other violent offenses out of Orange and Brevard, it looks like. As well as just has a fairly lengthy criminal history of other offenses using weapons and out-of-state history. Seems out of California, at least. So state would just ask for a reasonable bond, taking all that into account.
All right, thank you. Sir, at this time, your bond on count 1 is $25,000. Your bond on count 2 is $50,000. With special conditions, you can have no contact with the victim or any witness in this case. Do you understand what no contact means?
Yes, I do, Your Honor.
You can't possess a weapon of any kind, firearm or ammunition. And I'm ordering that you have to surrender this firearm within 24 hours of your release, sir.
Your Honor,
Yes, sir.
I am caretaker for a diabetic, insulin-dependent amputee who cannot be left alone at this time. I have no idea where these charges come from. None. I was at the mall.
Okay, well, we don't have to talk about that. Okay?
Sir, your attorney can file a motion in front of the trial judge to reduce your bond. So call the number on that green piece of paper right away.
This whole thing's killing a 77-year-old woman with an amputation.
We're gonna try to work on it. Don't give us a call. You're gonna get an attorney, we're gonna try to work on it.
So now, she can't get out of bed to feed her. You want to send social services?
I'll send an email.
Please tell me your name.
Roberto Rojas, Your Honor.
In 19 CF 13880, a capias was issued for your arrest for failing to appear for court on charges of burglary of a dwelling, grand theft, and criminal mischief. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck, sir. Please tell me your name.
Herman Sellers.
Good morning, sir. You're here because a capias was issued for your arrest in 21 CF 7219 for failing to appear for a trial management conference on a charge of petty theft with 2 prior convictions. The bond authorized on that capias is $5,000. I'll appoint an attorney to represent you. Good luck, sir.
Yeah, as long as you see like the difference.
Please tell me your name.
Scott Singleton.
Good morning. In 21 CF 14497, you're here because a warrant was issued for your arrest, charging you with fraudulent use of personal identification information and grand theft. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $5,000 on count 1, $1,000 on count 2. With special conditions, you can have no contact with any victim, witness, or co-defendant in this case. Do you understand what that means?
Yes, ma'am. I also have a question.
You can ask anything you want, but I want to make sure you understand everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am, I do.
Okay.
Okay, ma'am, what I wanted to ask was, I've been sitting on charges since September 26th when I got arrested in Arkadelphia, Arkansas, and Orange County came and got me October 11th, and I had my first appearance before you October 12th, and I've still been sitting on these charges, and the state hasn't picked it up, and my public defender awarded me of that on this past Monday, and I was told that a motion could have been filed, but I still, my public defender hasn't pushed to make that progress.
I don't understand what you're saying. This is a warrant.
I believe she's asking about another case, and she's wondering if there was a
Motion
she's
filed.
asking for is a 33-day motion,
Yes, ma'am, because I was,
which may not be filed until later this month, so in a few days.
She also has
Can't file it.
currently open 21 CF 2279. That was fraud on a person over 60 and F2, scheme to defraud F3, and 3 counts of fraud use of credit cards F3s. That was filed on 4/20/21. She previously had a 2019 petty theft and a 2019 grand theft. Both of those are no longer active. The only 2 cases I have are this one that's before the court today, and then that one previously talked about the F2s and F3s, which was filed in April.
What about 21 CF 2279?
That's the case.
That's that one. It was filed?
It's filed in April 20th, 2021.
All right, so the state did file those charges. So if what you're asking about is to be released on your own recognizance because you've sat in custody longer than 30 days and the state hasn't made a filing decision, that's not what's happened in this case. The state did file the charges.
okay.
So you can't be released on that.
Yeah, I was just confused about the whole situation.
I understand. All right. Good luck, ma'am.
Thank you.
Please tell me your name. In 21 CF 5617, a warrant was issued for your arrest for failing to appear for a status hearing on charges of aggravated assault with a deadly weapon and battery. The bond authorized on that is $2,500 on count 1, $100 on count 2. I'll appoint an attorney to represent you. And at this time, I'll take no action on the out on bond cases. Good luck, ma'am.
She already has them.
Excuse me.
Yes.
Say I had out on bond other charges.
Yes. But because of the uniqueness of a failure to appear, I'm not issuing, I'm not revoking that bond.
Okay, fine.
So I can get That's why. Thank you. Please tell me your name.
Michael Suarez.
All right, sir. In 21 CF 13994, a warrant was issued for your arrest, charging you with burglary of a structure with assault or battery, trafficking in oxycodone greater than 28 grams, robbery by sudden snatching, tampering with a witness to hinder communication to law enforcement, possession of alprazolam, criminal mischief, and resisting an officer without violence. Another judge has already found probable cause. I'll appoint an attorney to represent you. Yes, Ms. May?
Your Honor, given that count 1 is a first-degree felony that's punishable by life, state's asking that you hold a no bond pending an Arthur hearing. I understand the warrant otherwise came in with a bond. However, it is a punishable by life offense.
I agree. Mr. Brantz?
No argument, Your Honor. However, he is entitled to an Arthur hearing, and the warrant did come in with a bond, so you have that in your discretion, Your Honor.
Give me one moment. All right, sir, at this time, you'll have no bond on count 1. I think count 2 is low, but I'll leave it. Count 2 will be $50,000. Count 3, $5,000. Count 4, $1,000. Count 5, 6 and 7, $100. with special conditions. You can't return to this scene for any reason. You can't possess a weapon, firearm, or ammunition. You can't have contact with any victim, witness, or co-defendant in this case. Do you understand?
Yes.
In 21 CF 13738, a warrant was issued for your arrest, charging you with fleeing or attempting to elude law enforcement. Again, another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond in that case is $7,500. Did anyone look at the dates of his out on bond?
Yes, Your Honor. The warrants case is here for today. Date of offense, it was 9/6/21. His out on bond, 21 CF 8655. Date of incident was 7/21 or 7/22/21. And he bonded on that case.
7/24/21. All right, at this time, I'll revoke those bonds.
You want me to leave it on the paperwork?
Yes, and also in the fleeing or attempting to elude, you're not allowed to possess any weapons or firearms.
Since this coming to the warrant, we could take multiple months. We know this one, we put it in, so we know that one's forward. He was out on bond.
Please tell me your name. Thank you. 21 CF 14544. Sir, you're here charged with possession of cocaine and drug paraphernalia. There is probable cause. I'll appoint an attorney to represent you.
Do I have a bond?
You're going to have a bond in this case.
Yeah, hold on.
Yes, Mr. Brands?
Just in the interest of equity as to the similar charges of unemployed transient defendants, I would just have you set a similar bond amount on the current charge and perhaps if you are inclined to revoke, doubling down on bond.
Your Honor, I don't believe it's an issue of equity as each defendant's conditions are different. In this instant case, he's here for possession of cocaine. He's out on bond for possession of cocaine. He recently pled to a possession of cocaine 9/23/21 and has 3 prior failures to appear, the last being in 2021, as well as several other violent offenses, as well as drug offenses, as well as several VOPs showing an inability to comply with court orders. I don't think it's an issue of equity as each defendant's histories should be taken separately. And in this case, I believe it's a little bit more egregious being out on bond for one thing, picking it up again, recently playing to it, and having a lengthy history of it.
Your Honor, may I respond?
Go ahead.
My equity argument, I think the heart of the equity argument is that we're dealing with addiction issues. So even though
Dealing with what?
addiction issues, and I believe, obviously the facts of each case are going to be different, but I think at the heart of each case, there's an addiction problem.
So that's not why I changed those bonds in those cases, Counselor. It had to do with the facts of the case and their histories. In this case, I agree with the state. This case is different. He's out on bond for possession of cocaine, was recently sentenced for possession of cocaine, is now arrested for possessing cocaine again. So that's distinguishable from the other 2 cases who were not out on bond for this offense. However, similarly, he was cooperative with law enforcement.
Your Honor, Your Honor made the comment that he was cooperative with law enforcement. When law enforcement observed the male, who was later identified as the defendant, he made furtive movements to the right hand to dispose of unknown items behind the wall. So arguably, there could have been a tampering charge. He then made spontaneous utterances about having other items on him. However, I'm unsure regarding the complete compliance with law enforcement.
I mean, I see that the allegation is he hid the tube, but then he spontaneously uttered, "They're smoking. I can't smoke dope." There's no allegation he fought with law enforcement or battered them or resisted in any way. I do see that he has 3 prior failures to appear. Does anyone know what the sentence was for the possession of cocaine on September 23rd, 2021?
1 second, Your Honor. That case, it came in as possession of cocaine, destruction of evidence, possession of paraphernalia. We only filed the possession of cocaine. He was adjudicated guilty with 65 days credit time served. I believe he was sitting on potentially other cases as well
And was that a plea agreement?
with the state, Your Honor. Yes, Your Honor.
And I see that in his out on bond case, he was released on his own recognizance. Can you tell me why that is?
It was subject to a 33-day motion, but state has since filed.
So he's going to sit here for 32 days on this one. And then the defense is going to file a motion to release him on his own recognizance, which the state is going to ask the court to grant, right? Unless FDLE comes back.
It would give him credit time served that he otherwise would be pleading to at a later time, given his history. Your Honor, the history I'm looking at is, he has this 14544, possession of cocaine and paraphernalia. He has that 8586, cocaine and paraphernalia. He has a 5472 that he recently pled to, possession of cocaine. He has a 2020 possession of a controlled substance, 2019 possession of cocaine, 2019 possession of cocaine, 2018 paraphernalia, 17 cocaine, and then it disperses among other offenses. But from 2017 to date, it seems to have been a problem. At least in Orange County. I'm not sure out of county.
All right, sir, your bond is $500 on count 1, $100 on count 2. With special conditions, you can have no contact with any known drug dealers. You also can't possess or consume any controlled substance without a valid prescription. At this time, I'll revoke your ROR and set your bond on that case at $500 with the same conditions. Good luck, sir. Please tell me your name.
Wrong Washington.
Sir, you're here in 21 CF 14518, charged with burglary of a dwelling and criminal mischief. There is probable cause. I'll appoint an attorney to represent you. Does the state wish to be heard on bond?
Your Honor, he is otherwise entitled to a reasonable bond. His prior history is slightly concerning, and given the allegations within the affidavit, including his 3 prior failures to appear. And he has a history of bird conveyance, bird dwelling, grand theft dwelling. It would just ask for a reasonable bond as the victim's not here to testify.
Anything from the defense?
Just a reasonable bond, Your Honor, he's entitled to it.
He is. I share the state's concerns, as well as I see that there are 3 prior failures to appear. I also see that he has what looks to be not just an extensive history, but a history outside of our jurisdiction. All right, sir, at this time, your bond on count 1 is $15,000. Your bond on count 2 is $100. With special conditions, you can have no contact with the victim. You can't return to the scene for any reason. You can't possess a weapon, firearm, or ammunition. Do you understand?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Brenton Michael Watkins.
A capias was issued for your arrest in 21 CF 3052 for failing to appear for a status hearing on charges of driving while license suspended, resisting without violence, and battery on a law enforcement officer. There's no bond at this time, and I'll appoint an attorney to represent you. Good luck. Please tell me your name.
Scott Zulu.
You're here in 21 CF 14548, charged with fleeing or attempting to elude law enforcement with lights and sirens activated, possession of cannabis, and driving while license suspended. I'm going to appoint an attorney to represent you.
Your Honor, can it be heard as to probable cause?
Yes.
The affidavit is very short on facts. I know we've had discussions in the past about the threshold of the probable cause standard, totality of the circumstances. I don't know how the officer ID'd him, as he was allegedly eluding officers. So, again, this may be me being a stickler for the art of the arrest affidavit, but I would need more facts of what occurred in chronological order, setting a scene, that sort of thing. So I wouldn't have you find PC until a more detailed arrest affidavit is presented to the court, Your Honor.
What says the state?
Your Honor, for fleeing and attempting to elude, state only has to prove that he was operating a vehicle on a street or highway in Florida. And in this case, we do have an address in Orange County, so I believe we do have that element, and the state must prove that he duly authorized law enforcement officer ordered the defendant to stop or remain stopped. I do not believe we have that, so I do believe that defense makes a good argument that this could be a little bit more lengthy regarding facts. So state's asking for 24 hours to get an additional affidavit.
I'll give you 24 hours. I do think that there's probable cause for the cannabis, count 2. But
I don't think he checked the computer for the DeWillis either, officer. So
I'll give the state 24 hours. All right. We'll see you back here tomorrow, sir. Good luck. Yes.
Your Honor, I have one more case. I may have just missed it. Carl Dallas, 21 CF 9807.
We did him already.
We what?
He was already done. He was the second person.
I don't have it with me.
I never got an additional move-up list, so I never pulled them out. That's why I was confused.
Does the clerk have what we did? Okay.
We'll find it for you and give you.
Thank you. I appreciate that.
It was $500.
With standard petty theft conditions?
No return to scene.
All right, thank you.
Thank you. All right, anything else before court is adjourned?